Would you sign a deal if your only remedy for a broken product or for a defective service was for the supplier to replace the product or re-perform the service, even if the problem cost you a fortune? This is the function of a sole and exclusive remedies clause. It's a simple and common clause that can have a significant impact on your risk profile. I'm Mike, founder of Starlit Contracts, where we help you to negotiate and use contracts with confidence. We're looking at sole and exclusive remedies in this video. Firstly, what is a sole and exclusive remedies clause, and how does it work? Such clauses typically limit the remedies that a customer is entitled to when there's some wrongdoing by a supplier. The clause limits customers' remedies to what's mentioned in the contract and to those remedies that cannot be limited under applicable law. To put it another way, if a customer is potentially entitled to multiple remedies, such as for the payment of compensation and for the supplier to fix a defect, but the sole and exclusive remedy is for the supplier to fix the defect, then in many cases the customer will not be entitled to compensation. It's common to see sole and exclusive remedies clauses inserted several times in a contract. There can be a general catch-all sole and exclusive remedies clause or multiple such clauses under the warranty, limitations of liability, and liquidated damages or penalties clauses. Is this something you should care about? An advantage of sole and exclusive remedies clauses is that it makes clear what remedies apply in various circumstances. This means that a supplier is better able to establish its risk profile and is less likely to inflate the price with contingencies for risk that might not happen. The disadvantage for customers is that such clauses exclude their entitlement to remedies that would otherwise be available. Sole and exclusive remedies clauses also reduce the likelihood of more complex and expensive discussions after contract signature that could disrupt performance of the contract. Let's look at a practical example together. Defective Product Supplier Limited entered into a contract with customer. Supplier initially attempted to repair the defective product, but had to replace it soon afterwards. Customer now claims compensation for their losses for the period when the product was not working, and liquidated damages as well. What could go right for supplier in this situation? Supplier's strategy is to have the lowest price possible for its product. An essential part of the strategy is to minimize their risk by only using their standard form of contract, which has a favorable risk profile. The warranty, liquidated damages, and limitation of liability sections each have a sole and exclusive remedies clause. In this case, the sole and exclusive remedies clause in the warranty section means that customer is not entitled to remedies in addition to supplier's repair and replacement of the product. What could go wrong for supplier in this situation? Let's say that customer insisted on using their standard procurement contract, which does not have a sole and exclusive remedies clause. Customer may consequently claim any remedy to which they are entitled under the contract and under applicable law. Given customer incurred losses as a direct result of the defective product, they can claim compensation up to the cap on liability in addition to supplier replacing the defective product. Supplier has no risk contingency for such liability and they lose money on the deal. Let's look at a sample clause and some key considerations, and firstly to the sample clause. The rights and remedies in this clause or agreement are sole and exclusive, and exclude any right or remedy that may otherwise apply under applicable law. Now, one option is to include this statement once in the agreement and to specify that the remedies described in the whole agreement are sole and exclusive. The alternative is to include this statement for defined categories of risk, such as in the warranty clause, the clause for liquidated damages and penalties, if any, and for the cap and exclusions of liability. This latter approach is more advantageous for the supplier. It increases the likelihood that liability for each remedy is ring-fenced, so that a customer is less able to claim more than one remedy. Alternatively, if the parties agree that the remedies in the contract will not be sole and exclusive, then you can simply omit this clause from the contract. To wrap up, use sole and exclusive remedies clauses to fix the remedy that applies to important categories of liability, such as for warranties, liquidated damages, penalties, and for other limitations and exclusions of liability. Finally, if a customer does not accept having sole and exclusive remedies clauses, then be mindful that suppliers may want to increase the price to add some contingency for the higher level of risk. If you're ready to speak with an expert or to hire a lawyer, then check out starlitcontracts.com, where we will help you to retain a lawyer or law firm to address your requirements. I look forward to seeing you there.